My name is Mark Hewitt, and I'm with the Decker Hewitt Group at Canaccord Genuity. Today, I have the pleasure of speaking with Dwight Dee from Miller Thomson. Thanks for joining us today, Dwight.
Thanks,
with
Mark.
COVID-19 continuing to impact everyone in the world today, it has put a lot of attention on our healthcare system. As one example, we've all learned very quickly what it means to be intubated, which has been necessary for many people who have been struck by this disease. But what does this mean from an estate planning perspective? Should we be concerned that the plans we currently have in place might not be sufficient to address our health circumstances appropriately? What happens if we require intubation or become unable to make our own decisions? Dwight joins us today to speak to us and answer our questions on this topic, incapacity planning. Incapacity planning essentially addresses who will be able to make financial, legal, or healthcare decisions on our behalf if we lose the capacity to do so. Before I do begin, I'd like to give a brief intro to Dwight, and Dwight, you can add to this further once I'm done. Dwight's a partner at Miller Thomson. Our team's been working with him for several years. Dwight works with individuals and families in the areas of estate and incapacity planning, trusts, succession planning, and elder law matters. And this all includes the preparation of wills, enduring power of attorneys, family trusts, spousal trusts, and healthcare representation agreements. Today, he's going to delve into the details of incapacity planning and how to protect ourselves properly in keeping with our wishes. Over to you, Dwight.
Thanks very much, Mark. And thanks very much for the opportunity to share with you this morning about the importance of incapacity planning. And so as Mark suggested, what we'll be talking about today is the process of putting together the proper legal documents so that you can ensure that when you don't have the ability to do your own decision making, someone you trust can be put in place to deal with your financial and legal affairs and healthcare decisions so that you can make sure that your values and your wishes are expressed and followed through on. So we'll just go to the slides, and I hope the technology here works. Okay. So the good news, as many of you are probably aware, that Canadians are living longer, and the average life expectancy for the average Canadian has increased significantly over the course of the last century. And there's getting to be a larger number of Canadians over the age of 65 in our population. But a corollary to that, of course, is that many Canadians are living longer, but with some capacity issues, and dementia certainly is becoming an increasing problem in our society today. But moreover, as COVID-19 has demonstrated to us, even though we might not be old, our health can deteriorate quite unexpectedly and in ways where our capacity can be an issue. And so today we're going to talk about ways in which you can ensure that you've got the legal documents in place to address these circumstances. So to start off with, what happens if you lose capacity, but you have not done any advanced planning? There's two concepts that I want to briefly touch upon today. The first is a comiteeship or guardianship, and the second is the concept of a temporary substitute decision maker. When we talk about adult guardianship or comiteeships, there's a legal regime in place that provides that when a person no longer has capacity, another person can be appointed either through a statutory regime or through a court application to be able to effectively make decisions on the other person, on the incapacitated person's behalf. You might have heard of the term comiteeship. And a comitee is usually a family member or a close friend who makes a court application under the Patients Property Act in British Columbia to effectively be able to make legal and financial decisions and healthcare decisions on behalf of the person who's incapacitated. If there is nobody who is able to effectively make such an application, the public guardian and trustee under the Adult Guardianship Act could become a statutory property guardian. Now, these involve assessments that are made through the health authorities. And with respect to a committeeship, two doctors have to confirm that the person no longer has the capacity to manage their affairs or their person. The process for a committeeship is quite slow and it can be costly. And so when immediate decisions need to be made, when financial decisions need to be made, a committeeship can often delay those decisions, as nobody is able to make the decisions on behalf of the incapacitated person without any advanced planning. In addition, when you are a committee, there is annual reporting that needs to be done to the public guardian and trustee. In the case of a healthcare situation and that there is an immediate healthcare decision that needs to be made with respect to major healthcare and consent of the patient is required, if the patient is incapacitated and does not have capacity, the statutes provide that a healthcare provider must go through a fixed list of individuals where they are to consult with to get the consent. So in this particular situation, a healthcare provider needing to make or get consent from a patient would first go to a person's spouse, then a child, a parent, a sibling, a grandparent, and so on. The first person contacted who agrees to make the decisions, who is at least 19 years of age, has no dispute with the patient, and has been in touch with the patient for the last 12 months, becomes the temporary substitute decision maker. In the opinion of the healthcare provider, if there is no one available or qualified to be this temporary substitute decision maker, or there is a dispute with the person chosen, then the healthcare provider must choose a person authorized by the public guardian and trustee. So as you can see, the person that might be chosen to make the healthcare decision on your behalf might not be the person that you wish to be the person to make your healthcare decisions for you. Another disadvantage of having to rely on this temporary substitute decision maker is that there can only be one temporary substitute decision maker at the same time, and the consent or the choosing of that substitute decision maker must be renewed after a statutory period, which I believe is 40 days. This person can also not make any decisions with respect to your personal care, and there's also restrictions on the ability of the substitute decision maker to refuse consent in certain circumstances. So when we talk about incapacity planning, it is then to try to avoid these default situations that are put in place by statute. It will avoid the extra cost and extra time that is involved with the committeeship application and the uncertainty with respect to the temporary substitute decision maker. So I've set out in this table here the basic scheme of what we have for advanced planning. So you can see in this table that there is two main areas: incapacity planning and estate planning. And what I would just basically summarize is that incapacity planning is focused on your care. Who will make decisions for you when you are no longer, or if you are no longer, able to do so for yourself? The other main area of advanced planning would be estate planning. And generally, I would say that that is what you decide to do in terms of leaving a legacy when you are no longer around or after you have died. So estate planning focuses on assets. It focuses on what you wish to provide for your family or for people that are close to your heart. Incapacity planning is focused on your own care. So in British Columbia, incapacity planning is generally divided between healthcare and legal and financial affairs. With respect to health and personal care, there is the Representation Agreement Act, And with respect to legal and financial affairs, we have enduring powers of attorney. And that is what we'll focus on today. So with respect to representation agreements, there are two kinds, and we'll go through that. And we'll also discuss putting together an enduring power of attorney. So first, with respect to your legal and financial affairs, an enduring power of attorney allows you to appoint someone who can make decisions on your behalf, and it continues despite subsequent mental incapacity. An enduring power of attorney is a very flexible document. It allows you to either appoint one or multiple attorneys. It can allow you to appoint a primary attorney and a backup. You can provide for specific powers to be given to your attorney or give them broad powers or general powers. It can be effective immediately or only on the loss of capacity, and that is something we call a springing power of attorney, where it would spring into effect on the occurrence of a certain event. For example, when a doctor confirms that you are no longer able to make decisions for yourself. An enduring power of attorney can be revoked while you are capable. In order to make an enduring power of attorney, you need to know the approximate value of your property, your obligations owed to dependents. You need to understand the effect of a power of attorney, and that includes that you must understand that if an attorney does not manage your assets prudently, they can decline in value, and that the attorney may misuse the authority. You cannot appoint someone who provides personal care or health care services for compensation as your attorney, and it cannot be anyone who is an employee of a facility that provides personal care or health care services to you. One of the things that you can consider is you can consider appointing a professional trust company as your attorney. And so if you do not believe that there's anybody within your family or a friend who can act as your attorney, there are professional trust companies that are able to act as attorneys. So what does an attorney do? Well, an attorney primarily has the duty to act honestly, with reasonable care, and in your best interests. So when dealing with your legal and financial affairs, they must do all their tasks in your best interests. They also have to keep records with respect to your affairs, including your current wishes, and they need to abide by the directions within the power of attorney itself. Unless you state otherwise, an attorney cannot do certain things like receive compensation, transfer land to him or herself, and they must keep property, your property, separate from their own property. In the British Columbia Power of Attorney Act, there is also a limit as to the amount of gifts that an attorney can make on behalf of the adult that they are acting for. In the Act, unless you specifically specify that an attorney can make gifts, they would be restricted from doing so. An attorney can also not write a will for you or change your will. So what are some key considerations with respect to an enduring power of attorney? A lot of people, the first consideration, obviously, a lot of people can struggle with this, is who should you appoint? Will you appoint more than one person? Will you appoint more than one person concurrently? If you do appoint more than one person, generally you should include some sort of what I call a dispute resolution mechanism within the enduring power of attorney itself in the event that the attorneys cannot agree with a particular decision. Will you appoint one person as a primary attorney and a second person as a backup? Will you appoint a professional trustee? All of these will depend upon, obviously, the people in your life and effectively who you trust. And as I indicate here, trustworthiness is probably one of the principal considerations in terms of who you appoint as the attorney. The other is availability. in terms of someone who is close by, someone who you communicate with regularly, someone who is willing. All of those things are important to consider. Residency is an important consideration. One of the things that I encounter, not infrequently, is where a parent wants to appoint a child who might be resident in another country, for example, in the United States. There's some considerations when you appoint an attorney that is a resident of the United States, for example. If your attorney is a resident of the United States, there are reporting requirements under US law called FBARs. And so this reporting can be quite onerous. It requires them to report the accounts that they might have authority over, and it's a report to the US government. If you also have an attorney that's in a different jurisdiction, they might also have difficulty in terms of dealing with your investment accounts, as securities laws tend to limit where instructions, who can give instructions to, for example, an investment advisor. So that might be another just practical consideration when appointing someone from a different jurisdiction. I always just ask people to reflect on family dynamics with respect to who you appoint as the attorney. Certainly, when there are multiple children or siblings that are appointed, you have to understand whether or not they can work together, whether or not the people that you appoint can come to decisions quickly together, and the personalities involved. The other important consideration that you need to think about is the nature of your assets and your financial affairs. Do you have assets that are fairly complex, such as business assets, interest in private companies? Do you have particular assets that require understanding or special expertise? If you have, for example, business assets, such as shares in private corporations, one of the considerations might be whether or not your attorney has private company shares of their own. Because under the Income Tax Act, when you appoint an attorney that has power over voting your private company shares, Section 251 of the Income Tax Act might make the attorney's companies that they have shares in related companies with your own. And that might create a situation where you lose, for example, the small business deduction, and it might have other adverse effects. Do you want to restrict the ability of your attorney to do certain things or give broad powers? Do you, for example, want them to be able to make gifts out of your assets? Do you want oversight? For example, would you like the attorney to report, for example, to, if it's one child that you've appointed, to report to the other children on their activities that they are, the tasks that they perform as attorney? With respect to compensation, unless you specifically indicate compensation to your attorney in the power of attorney document, then compensation would not be permitted. And you need to not only say that there is compensation, that the attorney can receive compensation, but you actually also have to set the rate. And that's a requirement of our Power of Attorney Act. If you have land or property, there are special land title requirements with respect to your attorney being able to deal with land. So that is something that needs to be considered as well. So powers of attorney are specifically with respect to legal and financial matters. Now we turn to representation agreements, which are the agreements or the document that you could put in place to deal with personal and healthcare decisions that can be made on your behalf if you lose capacity. Personal care includes living arrangements, diet and social activities, and healthcare includes minor healthcare and major healthcare, and includes refusing treatment. Representation agreements under a Representation Agreement Act are fairly flexible documents, and you can appoint one or multiple representatives. You can appoint alternative representatives. You can give representatives different scopes of authority, and you can specifically narrow an authority of one representative and give broad powers to another. So there's quite a bit of flexibility that you can make in these representation agreements. There are primarily two kinds of representation agreements in British Columbia. Section 7, which is typically called a standard representation agreement, which I would say is a bit of a misnomer, and I'll get to explain why, but there's the Section 7 and then the Section 9. Typically, for clients that have capacity, that are able to make decisions and understand a representation agreement, the recommendation is to do a Section 9 agreement. So that is why I sometimes say the Section 7 being called a standard agreement isn't the one that should be the standard, I think. Section 9 is the one that most people who have capacity should use. The Section 9 agreement is the one that gives the broadest range of authority possible. It gives your representative the ability to refuse consent to healthcare necessary to preserve life. And it also includes a broader range of personal care, including the ability for your representative to agree to admittance into a care facility. So unless capacity is already in question, we typically recommend a Section 9 representation agreement. So what are some considerations for a Section 9 representation agreement? Obviously, just like an enduring power of attorney, you need to think of who to appoint. Now, one of the things that you want to think about is coordinating who are your representatives under a representation agreement and who might be appointed as attorney under your enduring power of attorney. If you think that the scope of authority for healthcare decisions should be a different person than a person that you would appoint under your enduring power of attorney, you need to make sure that there is some coordination, because if a healthcare decision is made by your representative, that healthcare decision might need to be funded by the person who is controlling your financial assets under the enduring power of attorney. And so if there's conflict between the two people, you need to be able to resolve that, and the documents should hang together. If you appoint multiple representatives, then again, you should think about how decisions can be made if there is an impasse. You might want to think about restricting the powers of the representative, and certain treatments under our health set out in our healthcare regulations require explicit authority under a representation agreement. In other words, unless you give the power to the representative to make to consent or to refuse these types of healthcare, the representative would not be able to deal with those types of decisions. Do you want your representative to maintain certain types of records? Do you want your representative to follow written wishes within the document itself? And we'll talk a little bit about that in one of the upcoming slides. But you have the option in a representation agreement to express your specific wishes in the actual agreement itself, or in a separate document like a letter of wishes. The Representation Agreement Act also has a concept called a monitor. A monitor is effectively someone that you appoint that will give oversight to your representative. The monitor is able to ask the representative for records, for inquire about their decisions, and whether or not you have actually followed whether or not the representative has followed the appointer's wishes. If the monitor determines that the representative is not acting in accordance with your wishes, they can make a report to the public guardian and trustee. So a Section 9 representation agreement is something that is available to someone who has full capacity. And that is what we typically recommend, as I've suggested. The alternative is a Section 7 representation agreement. And a Section 7 representation agreement is used when capacity of the individual is limited. Typically, these representation agreements are used for persons who've had a lifelong disability, or where a person already suffers from some sort of mental incapacity. and they have not been able to prepare a Section 9 agreement. A Section 7 agreement covers healthcare decisions, but they cannot deal with life-saving treatment decisions, so they cannot refuse a life-saving treatment, and they can also not consent to physically restrain or manage a person. A Section 7 agreement can also give authority so that a person can make routine financial management decisions, such as paying bills, buying necessities, and making investments. There is a long list of what is considered to be routine financial management decisions, and there is a list as well of what would not be considered to be routine. For example, the sale of real estate would not be considered to be routine financial management. If you decide, or if a person uses a Section 7 agreement and decides that the authority of dealing with routine financial management is included, then you must appoint a monitor to oversee the actions of the representative. For both Section 7 and Section 9 agreements, the duties of a representative include ensuring that they consult with you and follow your wishes to the extent reasonable. And like an attorney, they must act in good faith and with reasonable care. They must also keep accounts and records of their exercise of authority. It's important to note that in a representation agreement, the importance is that the representative must follow your wishes to the extent known and reasonable. In a power of attorney, the attorney must act in your best interests. So a representative under a representation agreement might be limited pursuant to the terms of the representation agreement. They cannot delegate authority except for investments. And like an enduring power of attorney, they cannot write or rewrite your will. The most important thing with respect to a representation agreement really is ensuring that the representative that you appoint is someone that you trust and knows your wishes. And so in terms of considering and determining your wishes, there is some guidance that have been put out by the provincial health authorities as to the types of questions that you should be considering with respect to healthcare decisions. So what is the most important to you that makes your life meaningful? What types of healthcare treatments would you agree or refuse to if a healthcare provider recommends them? Would you accept or refuse life-prolonging medical interventions, and in what circumstances? What are your preferences should you need residential care and not be able to be cared for at home? These are the types of questions that you should be considering and then discussing with your representative to make sure that they are aware of what your values are and what your wishes are. So when you communicate with your representative, you can either do that verbally and ensure that they know what your wishes are. Also, you have the option of including your specific wishes in the representation agreement or in a separate document, like a letter of wishes. The decision whether or not you want to include it specifically in the representation agreement is a personal one. Some people don't like to include those wishes in the representation agreement in case their wishes change in the future, and they would rather ensure that they can have that open communication to be flexible with their representative. Also, in situations where there's difficult family dynamics, perhaps siblings that don't get along with each other, and you've appointed one sibling over others, including wishes in a representation agreement might sometimes invite conflict, especially if one sibling, for example, wants to say that you have not followed this wish particularly exactly as expressed, and so it can invite sometimes room for conflict. On the other hand, including your wishes in writing obviously makes everybody know what your wishes are. More than just communicating your wishes and your values once, you should continue to communicate your wishes as your life circumstances change. if you've had a diagnosis, for example, if you're going into a particular surgery or operation, you should make your wishes known at that time so that your representative knows exactly what you are thinking at a specific life circumstance. So outside of representation agreements, the statutes in British Columbia also allow for what we call advance directives. I'll only briefly touch upon advance directives because typically we recommend healthcare agreements or healthcare decisions to be made through a representation agreement. But in certain circumstances, advance directives can be used by an individual, especially when they are unable to choose a representative for a representation agreement. So advance directive is a written document where an adult gives consent or refuses consent to a specific healthcare treatment that is actually mentioned or described in the advance directive. So an adult must have capacity to understand what the advance directive covers in order to make an advance directive. So it is essentially instructions to a healthcare provider that must be followed if the directive addresses the treatment that is needed at that time and is described in the advance directive. An advance directive is has a limited effectiveness, I would say. An advance directive will not apply in many circumstances, including if a healthcare provider reasonably believes that the directive is unclear, it does not address the form of care that you need, you later significantly change your values or your beliefs about healthcare, or that there have been significant changes to medical treatment since the directive was made. And so in those types of situations, an advance directive could be set aside and a decision would then need to be made by the temporary substitute decision maker if you do not have a representation agreement appointing someone as a representative. You can combine a representation agreement with an advance directive if you so choose. And effectively, that will be in a situation where you want to ensure that your very specific wishes are followed by the healthcare provider. I think that would be in a limited circumstance, and you would need to direct in your representation agreement that the advance directive should be followed and not the decision of the representative with respect to the healthcare covered by the advance directive. And I'll just end off now with a couple of issues that have just more recently come up. So COVID-19 has created a lot of thinking of people with respect to incapacity planning. And it's brought to light that illnesses can happen quickly, hamper communication, and include a loss of consciousness. COVID-19 could impact through treatment your mental capacity. And so the healthcare authorities have put out some guidance with respect to what treatments involve, what types of care and outcomes can be expected as a result of certain types of intervention. The BC Palliative Care Society has put out some guidance, and I've put in the link there, with respect to what can be expected in terms of different types of interventions with respect to COVID-19. But what I would say is that COVID-19 has heightened the importance of continuing communication with your representatives and with your loved ones with respect to your values and wishes with respect to healthcare decisions. Diseases and illnesses like COVID-19 can happen quite quickly. And so that communication up front is obviously significant and very helpful. Medical assistance in dying is also something that people ask about with respect to incapacity planning. At this time, the legislation under our criminal code does not allow someone to be appointed in advance to consent to medical assistance in dying. There are proposed amendments, not yet in force, that will allow an individual to consent, but if in the intervening time before the medical assistance in dying is provided, they lose capacity, the final consent could be waived if death is reasonably foreseeable. So just to summarize and just to end off, with respect to incapacity planning, you should have an enduring power of attorney to deal with your financial and legal affairs. You should have a representation agreement, a Section 9 representation agreement that appoints someone to deal with your healthcare and personal care decisions. You should communicate with your appointed representatives your wishes and values. And you should consider updating your documents and continuing your communication as your circumstances change over time. I've left this final slide here with further resources. The province of British Columbia has compiled a very good document called My Voice, expressing my wishes for future healthcare treatment, and it's found through that link there. It is a very comprehensive document that explains much of what I've covered in this presentation today, and it also includes samples of representation agreements that you can use to put together your own planning. A lot of people ask the question, do I need to see a lawyer to put these documents in place? There's no legal requirement for you to see a lawyer to actually put together a representation agreement or an enduring power of attorney. There are formality requirements with respect to the execution of these documents, which having a lawyer in place makes things a bit easier, but you can certainly prepare these documents yourself. Obviously, these are legal documents, and so as a lawyer, I do advise clients to get appropriate legal advice in preparing the documents, and to also walk you through the implications of your decisions. That concludes the presentation. I hope that was useful. So Mark, back over to you.
Yeah, thanks, Dwight. That was very informative and timely as well. I do have a few questions that have come in. I'll just go through them from the beginning. So one was, if before I've had the chance to update my living will, I become incapacitated, but I've let my family know my wishes, is this legally binding?
So the term living will is oftentimes used kind of colloquially. That term living will is not an actual legal document in British Columbia. You might be talking about an advance directive. And as I've indicated, an advance directive will not be in effect if your values change since the time that you made your advance directive. But if there's no representation agreement in place, if a healthcare decision needs to be made, the healthcare provider would then go to that temporary substitute decision maker. And assuming that the temporary substitute decision maker is approached, that knows your values and wishes, then hopefully they will then make the decisions based on the values and the wishes that you've articulated to them. But again, what would be best is that you put in a representation agreement that would designate a person to be able to make the decisions on your behalf, and that person knowing your current values and wishes.
Great, thanks. Another one here, a client's mother is currently hospitalized because of health issues. Due to the COVID outbreak, the client has limited contact and communications with the mother. What does the client need to do to prepare for the possibility of future incapacity while the mother is still alive?
So I guess my question is, the mother currently has capacity right now, and if they leave the hospital, they're able to perhaps prepare a representation agreement, or
I think both cases. If they do have capacity, but also what if they don't have capacity?
Okay, well, if they don't have capacity, so if they do have capacity, obviously the recommendation would be to prepare an enduring power of attorney and representation agreement. If in the event that they don't have capacity anymore, the first question with respect to what the options are would be, would they be able to prepare a Section 7 representation agreement? And the capacity test for a Section 7 is diminished. It's not the same level of capacity as would be required for a Section 9. In a Section 7 circumstance, you look at the overall situation of the person wishing to appoint a representative. Are they able to indicate decision-making with a yes and a no? Are they able to communicate that they trust someone? So all of those circumstances would need to be considered to see if a Section 7 would be available to be made. And if the Section 7 is sufficient, then that could be used for further decision-making in the future. The last, I guess, resort is a committeeship application. So if a person no longer has capacity, then a family member could apply to become the person's committee, and that would involve a court application. The court application would require 2 doctors to confirm that the patient or the person is no longer capable, and would also require affidavits with respect to the person's assets. So it is a fairly involved process to do a committeeship application. It involves supervision and review by the public guardian and trustee. So those are the kind of options that are available to a person who no longer has capacity.
How long does something like that take?
Well, right now the courts are closed, so it's only available in emergency type situations. So if you do have an emergency, you can, and in a committeeship application, if you can say that it is an emergency, you can get into court now. But typically, the challenges that I've had in doing committeeship applications is, number one, you need to get the 2 physicians to confirm the person no longer has mental capacity. And so that requires them to do an assessment, and then after that, swear an affidavit. That sometimes can take time, depending upon the availability of the physician, the availability of the patient to do an assessment. So that's one threshold. The other is then you file the application, and then the public guardian and trustee has the opportunity to review the application. And I believe they have 21 days to review that. So I think the fastest you would be able to get it done would probably be about 5 weeks. So there is a bit of a delay, and that's if you get everything kind of all your ducks in a row and everything kind of falls together nicely. Unfortunately, and this is very recent, the last committeeship application that I have been doing for a client, unfortunately, the client was the spouse who wanted to be appointed the committee, but the person passed away while we were preparing the committeeship application. So that kind of, shows the importance of trying to do this advanced planning so that that circumstance can be avoided.
Perhaps one final question here, good one to end with. What's the most common mistake or omission you see people making in regards to their legal healthcare decisions?
I think one of the, I think that with respect to, if you've got very simple and straightforward circumstances, then, maybe this doesn't apply. But I think one of the things that is the most implications is when you appoint attorneys that do not get along with each other, or you appoint representatives that do not get along with each other. We've had situations where you've had children who are both appointed, and this was appointed when obviously life circumstances might have been different, but there might have been a falling out, or potentially one child, for example, that is wealthier, considerably wealthier than another. And so their decisions about how to use mom and dad's assets are going to come from different places. And so it creates situations where, you know, one person wants to do X and another person does Y, and it creates conflict. And so who you choose to be your representative, who you choose to be your attorney, makes the most difference. It's the most critical decision. And then after that, all the other things flow into place. If you appoint people that you trust, then I think you're 80% there, right? Because then you know that the person will follow what's in your best interest and will follow your wishes. But the biggest mistake is appointing people who can't make decisions together, who disagree, and who end up, you know, getting involved in a conflict. And that's certainly not what you want. These documents are largely to try to avoid those things.
Right. Great. Thanks, Dwight. That was very, very good. A lot of information there. We do have the presentation available to send out. So if you would like to see that, just contact one of us on the team. And if you have any further questions as well, contact one of us on the team, and we can get you in touch with Dwight. Thanks again, Dwight. Next week, we'd like you join us for our weekly Zoom call. Eric Decker, myself, and Sean LaBelle will be hosting the monthly trade commentary call, reviewing what happened in May and how we're currently positioned in the markets. So don't miss it. Have a great weekend, everyone, and cheers.